My mother stood up in front of 9 jurors, pointed at me, and said, "She never served a day in her life. Not one day." I was 41 years old, a retired lieutenant colonel, with 22 years of federal service, sitting 3 feet from the flag of the state of Ohio, and I did not blink. If you are watching this from a courthouse parking lot on your lunch break, or from a base barracks after a 12-hour shift, or from a hospital waiting room where somebody you love is running out of time, comment the city you're watching from right now, then hit like and subscribe, because what happened in that courtroom in Franklin County is the reason I stopped explaining myself to people who never asked a single honest question in 22 years. My father, Harold Keller, died on a Tuesday in March, with a trust worth $4.1 million, sitting untouched since 2003. And inside that trust was a single clause my mother had spent 11 months trying to erase, that his estate be split evenly between his 2 daughters, myself, and my younger sister Melissa, unless one of us was, in the language of the document, proven unfit for the responsibility of inheritance. My mother, Diane Keller, 68 years old, had decided that unfit meant me, not because of anything I had done, but because of everything I had never explained. For 22 years I told my family I worked logistics, that I processed paperwork, that my deployments were administrative. That was the cover story. It was also, technically, not a lie, the way a locked door is technically still a door. What was actually true is that I served with a Joint Special Operations Medical Logistics Cell, that I held a top-secret/SCI clearance for 19 of those 22 years, and that 3 separate incident reports with my name redacted are sitting in a vault in Tampa that I am not legally permitted to describe to you, or to my own mother, or to a Franklin County probate judge, unless the right envelope arrives at the right moment. That envelope is the reason I am telling you this story at all. There were 3 threads pulling at me that spring, and I want you to hold on to all 3, because the way they came apart in that courtroom is not something Hollywood would dare write, and it is, God help me, all true. The first thread was the trust contest itself, my mother's petition to strip me of my half of my father's estate, filed 9 days after his funeral, built entirely on the claim that my military service was fabricated or exaggerated, and therefore that I was, in her words on the record, not the daughter he thought he raised. The second thread was my husband, Gregory Hart, a commercial real estate broker in Columbus, who I had been married to for 11 years, and who I would learn, in the ugliest possible way, had already decided which side of my family he was betting on. The third thread, the one that took the longest to surface and cost the most when it finally did, was a sealed manila folder that had been sitting in my father's safe deposit box since before I ever put on a uniform, a folder my father's attorney handed to me at the reading of the will with 4 words, "He wanted you ready." I did not open it that day. I put it in the trunk of my Camry and did not touch it again for 6 weeks, because some things you are not ready to read, even when someone tells you that you are. I need to take you back to explain how my mother arrived at a courtroom podium calling her own daughter a liar, because it did not happen overnight. It happened over 22 years of small erasures that added up to one enormous one. I enlisted in 2002, 6 months after finishing my degree at Ohio State, against my mother's explicit wishes. She wanted me to teach elementary school, like she had for 31 years in Westerville. My father, a Vietnam-era Army mechanic, who never saw combat and always regretted it, drove me to the recruiting station himself, and told the recruiter, loud enough for the whole strip mall parking lot to hear, "She's smarter than every man in this building. Treat her right." My mother did not come to that appointment. She did not come to my basic training graduation at Fort Jackson either, citing a scheduling conflict with a school board meeting that, I would later confirm, did not exist that week. From the very beginning, my service was something that happened to my mother, not something she participated in, and she resented it in a way she never had the vocabulary or the willingness to name directly. Instead, she renamed it. At Thanksgiving in 2005, when I mentioned I would be traveling for an extended training rotation, she told her book club I was doing something with computers. In 2009, when I came home for 2 weeks between assignments with a haircut regulation length, and 12 pounds lighter than when I'd left. She told my Aunt Carol I had been under a lot of stress at the office. By 2014, the story had calcified into something she repeated so often she seemed to believe it herself. That I did paperwork for the army, that I had never really been in danger, that my sister Melissa, who became a labor and delivery nurse in Dayton and never left the state of Ohio for longer than a weekend, was the daughter who had actually built a real, sacrificial, honest life. Melissa, to her credit, never weaponized this the way my mother did. Not at first. Melissa and I were close as children, close enough that when I made captain in 2007, she flew to Fort Bragg on her own dime, just to see the promotion ceremony. Close enough that she was the only person in my family who ever asked me a direct question about what I actually did, and accepted "I can't talk about it" as a complete answer, instead of an insult. That changed, slowly, after my father's diagnosis. Pancreatic cancer, stage 3, diagnosed in June, and from June to March I watched my mother recruit my sister, inch by inch, into a narrative where inheritance and love had become the same transaction, where every hour Melissa spent driving our father to Dayton for chemotherapy was quietly tallied against every year I had spent playing soldier. Her words, spoken once in a moment of exhaustion, in a hospital hallway, I don't think she meant for me to overhear, and never apologized for. I was overseas for 6 weeks of my father's decline, at a location I still cannot name. And when I came back, the tally had already been finalized in my mother's mind. I had missed the hardest part. Therefore, I had not earned the reward. It did not matter that I called my father every single week I was in country, using a satellite line that violated at least 2 regulations I chose to violate anyway. It did not matter that he told me, on our last real conversation, 3 days before he slipped into the sedation that took his voice for good, "You did more for this family than anyone will ever let you say, and someday, somebody's going to make them say it out loud." I did not understand what he meant by that, until the manila folder, and by then, it was almost too late to matter. My father died at 4:47 in the morning, on a Tuesday in March, in a hospice room that smelled like antiseptic, and the eucalyptus oil my sister kept dabbing on his pillow, with my mother holding his left hand, and me holding his right. And for exactly 9 days after that, there was a fragile, grief-soaked ceasefire in my family. Then the will was read. Franklin County, a conference room on the 4th floor of a law office on East Broad Street. My father's longtime attorney, a soft-spoken man named Arthur Beaumont, who had drafted every version of that trust since 2003, reading the terms aloud in a flat, professional voice. The estate, $4.1 million in a mix of real property, brokerage accounts, and a small manufacturing business my father had built from a single lathe in a rented garage in 1979, to be divided equally between his 2 daughters, with a single condition attached. A clause my father had added in 2011, after what Arthur described only as a family conversation I wasn't present for, stating that either beneficiary could be deemed ineligible if a court of competent jurisdiction found that beneficiary had materially misrepresented facts material to the decedent's estate planning intentions. My mother's attorney, a sharp-suited man named Craig Delvecchio, with an expensive watch he checked 4 times during the reading, was already taking notes before Arthur finished the sentence. I did not know it yet, but that clause, meant by my father as a general safeguard against fraud, was about to become the exact weapon my mother would use against me, twisted into an argument that my entire military career was itself the material misrepresentation. 9 days after burying her husband, my mother filed a trust contest petition in Franklin County Probate Court, naming me as the respondent, requesting that my half of the estate be declared forfeit and redistributed entirely to my sister, on the theory that I had spent 2 decades deceiving my father, and by extension the entire family, about the nature and reality of my military service, and that this deception was itself a material misrepresentation, sufficient to trigger forfeiture. I read the petition standing in my own kitchen at 9:40 on a Thursday morning, Gregory's coffee mug still warm on the counter where he'd left it, before heading to a closing across town, and I remember setting the papers down very carefully, the way you set down something that might otherwise become a weapon in your hand. and calling the one person in Columbus I trusted enough to make this call to. That person was Colonel James Jim Osric, retired, JAG Corps, 29 years of service, a man I had served alongside for exactly one classified rotation in 2016, and who I had run into 18 months earlier at a VA fundraiser in Dublin, Ohio. Of all unlikely places, both of us reaching for the same shrimp cocktail. Jim was 62, built like a retired linebacker, with a habit of pausing for 4 full seconds before answering any question. A habit that used to drive junior officers insane, and that I had come to understand as the sound of a man refusing to speak faster than the truth could be verified. When I read him the petition over the phone, he was quiet for those 4 seconds, and then he said, "Rachel, I need you to come to my office, and I need you to bring me every DD-214, every fitness report, and every commendation you've got, redacted or not, and I need you to understand something before you walk in that door. This is not going to be a fight about your father's money. This is going to be a fight about whether you get to keep your own name." He took the case for $1, a formality so the engagement letter would hold up, and told me the actual fee would be settled later, when the dust clears, and we both know what you're worth to this family, which is more than any of them currently understand. It was Jim, sitting across from me at his office on High Street, 3 weeks into discovery, who first asked me the question nobody else in 11 years of marriage or 41 years of family had bothered to ask directly. "Rachel, is there anything in your file that could end this in one afternoon if it ever saw daylight?" I told him about the folder. The manila folder from my father's safe deposit box, still sitting untouched in the trunk of my Camry, 6 weeks old and gathering road dust. 4 words from Arthur Beaumont rattling in my skull every time I opened that trunk to get groceries out. He wanted you ready. Jim did not tell me to open it that day either. He told me something stranger. "Don't open it yet. Not until I've filed the right motion to make sure whatever's in there can actually be used, instead of used against you." I did not fully understand what he meant until much later, and I want you to sit with that folder in the trunk of that car for a while longer too, because that is exactly how long I had to sit with it. While Jim built the legal case, I was living a second life that had nothing to do with courtrooms, and this is the part of the story where you need to understand exactly what kind of people surrounded me during the worst 9 months of my adult life. There was my mother-in-law, Patricia Hart, a retired hospital administrator who had never once in 11 years asked me a single question about my deployments, but who managed, at every family dinner, to find a way to mention how grounded and present her son's first wife had been, a woman named Cynthia who Gregory divorced in 2013, for reasons he described to me once, briefly, as she wanted more than I could give at the time. Patricia's fixed trait, if you want to call it that, was a specific brand of moral superiority, delivered entirely through comparison, never through direct confrontation, so that by the end of any given dinner, you left the table feeling smaller, without being able to point to a single sentence that had actually attacked you. At the 4th of July barbecue that year, 4 months after my father's funeral and 2 months into the trust litigation, Patricia said, in front of both families, stirring her potato salad, "It must be nice to have a job where nobody can ever check your work." I put down my fork. Gregory laughed. That laugh told me more about where this marriage was heading than anything Patricia ever said directly. There was Craig Del Vecchio, my mother's attorney, whose fixed trait was a calculated arrogance he wore like a second suit, the kind of prepotencia calculista that shows up specifically in depositions, where he would ask me the same question 4 different ways, hoping the 5th phrasing would trip something loose. In my deposition in August, 7 hours in a windowless conference room, he leaned back in his chair and said, "Ms. Keller, can you name a single specific incident, with a date, a location, and an outcome, that would corroborate any of the vague claims your father apparently believed about your career?" I said, "No, I can't, and I'm not going to try." He smiled like a man who had just won something. He had no idea he was about to lose everything he thought he understood about what silence actually meant. And there was Melissa, my sister, whose relationship to me during this period was the most painful thread of all, precisely because it wasn't fixed. It wasn't simple. It wobbled between old loyalty and new resentment, in a way that felt, some days, like watching someone drown slowly enough that you kept believing you still had time to reach them. In September, Melissa came to my house alone, without telling our mother, and sat at my kitchen table for 2 hours, mostly in silence, before finally saying, "I don't actually think you lied, Rachel. I think Mom needed somebody to blame for missing the parts of Dad's life she couldn't stand missing. And it was easier to blame you than to blame herself for not asking harder questions." I asked her if she was going to say that in court. She looked at her hands and said, "I don't know yet." That answer hurt more than anything Craig Delvecchio ever said in a deposition, because it meant the person I loved most in that family was still deciding whether $4.1 million was worth more than the truth. The betrayal that broke something permanent in me, though, did not come from my mother, my mother-in-law, or my sister. It came from Gregory, on a Tuesday evening in October, 7 months after my father's death, 5 months into active litigation, when I came home from a deposition prep session with Jim to find Gregory's business partner's wife, a woman named Sherry Doyle, already knowing things about my case that I had never told her husband, let alone her. I asked Gregory, calmly, how Sherry knew the specifics of my deposition. He told me, after a long silence that mirrored Jim's 4-second pauses but carried none of the same integrity, that he had been talking to Sherry as a friend for several months, that things had gotten complicated, and that he thought, given everything going on with your family, it might be better if we took some space while the litigation resolved. He said this while I was still holding my car keys, still wearing the blazer I had worn into a room where a man twice my age had tried to make me cry on the record and failed. He filed for divorce 11 days later. His attorney's filing specifically cited, as grounds for an expedited custody and asset conversation regarding our joint properties, my unstable financial position, given the pending trust litigation, and its potential impact on marital assets. A sentence that told me everything about which side of my family Gregory had already placed his bet on, months before any court had ruled on anything at all. I did not cry in front of him. I want to be precise about that, because precision is the only thing I had left that nobody could take from me. I went upstairs, packed a single duffel bag with the same efficiency I'd once used to pack for a 72-hour notice deployment, and drove to Jim Osrich's office at 9 at night, where his paralegal let me sit in the conference room until Jim himself arrived 20 minutes later in sweatpants, having driven straight from his own house, because I hadn't said a single word on the phone except, "I need somewhere to think." He sat across from me, 4 seconds of silence, and then he said the thing that changed the entire shape of what came next. "Rachel, I think it's time. I filed the protective motion 2 weeks ago. The folder in your trunk, bring it in tomorrow morning. Let's find out what your father wanted you ready for." If you've made it this far, you already understand this is not a story about money, even though $4.1 million sat at the center of it like a stone in still water. It's a story about what happens when the people who are supposed to know you best decide it's easier to believe the smallest version of you. So before we get to that folder, and to what happened when 9 jurors and 1 judge finally heard what was inside it, hit like on this video and subscribe now, because if any part of this has made your chest go tight, the way mine did in that conference room, you already know there's a piece of your own story you've been carrying quietly too, and you deserve to hear how mine ended before you decide what to do with that. The folder, when I finally opened it on Jim's conference table at 7:15 the next morning, contained 11 pages, a photocopy of a Silver Star recommendation, my name partially redacted, tied to an incident in 2016 my father had somehow learned about through a mutual contact from his own Vietnam-era VFW post, a recommendation that had been downgraded for classification reasons to a lesser commendation that never once appeared on any document my mother had ever seen. A handwritten letter from my father, dated 4 years before his diagnosis, addressed to whoever needs to see this someday, describing a phone call he'd received in 2016 from a general, whose name I still cannot say publicly, informing him only that his daughter had done something in the last 6 months that most soldiers never get the chance to do in a career, and that he should be prouder of her than he'll ever be allowed to explain. And a business card, worn soft at the corners, for a Major General named Frank Castellano, retired, with a Virginia phone number and a single line in my father's handwriting. Call him. He said if it ever mattered, he'd tell them himself. Jim called that number at 7:40 in the morning. General Castellano, 71 years old, retired 8 years, remembered my name before Jim finished his second sentence. When Jim explained the situation, the trust contest, my mother's petition, the specific claim that I had fabricated or exaggerated my service, there was a silence on the other end of the line that lasted longer than any of Jim's 4-second pauses. And then General Castellano said something I did not hear directly, but that Jim repeated to me with his hand pressed flat against his own chest, like he needed to steady himself to say it out loud. Colonel Osric, you tell Rachel Keller that if her own mother wants to stand in a courtroom and call her a liar, I will personally submit a declaration, and if the court needs more than my word, I will make 3 phone calls that will put a properly redacted but entirely real service record in front of that judge inside of 2 weeks. Nobody calls Rachel Keller a fraud while I'm still breathing. Jim filed the motion to introduce supplemental evidence the following Monday. The trial was scheduled to begin in 6 weeks. My mother's attorney, Craig Del Vecchio, objected to the motion twice, calling it, in his filing, an 11th-hour attempt to manufacture sympathy through unverifiable and likely inadmissible classified material. He had no idea how wrong that word unverifiable was about to prove itself to be. The 6 weeks before trial were the hardest of my adult life, harder in a strange, quiet way than any deployment I'd ever served. Gregory moved his things out over 3 separate weekends, always scheduled for when I was at depositions, so that I came home each time to a house that felt 1 room emptier than the last. His side of the closet, then his study, then finally the guest bathroom cabinet, where he'd kept his razor for 11 years. Patricia Hart sent one text message during this period, not to me, but forwarded to me accidentally by Gregory, in a moment of carelessness, that told its own story. Tell her I hope she gets what's fair. Cynthia never made things this complicated. Melissa called me twice a week, sometimes just to talk about nothing, our father's old records collection, a recipe our grandmother used to make, and I let her, because some part of me still believed that whatever she decided to say in that courtroom, the sister who sat at my kitchen table in September was still somewhere inside the one who might, in the end, choose our mother. The trial began on a Monday in late November, in a Franklin County courtroom with high plaster ceilings and radiators that clanked every 20 minutes. 9 jurors seated to my left, my mother, and Craig Del Vecchio at the plaintiff's table, close enough that I could see the exact moment Craig adjusted his cufflinks before every objection, a nervous habit I'd catalogued over 4 months of depositions. My mother testified on the second day. She wore the navy dress she'd worn to my father's funeral, and she cried at exactly the moments Craig had clearly rehearsed her to cry at. And then, on cross-examination, when Jim asked her plainly whether she had ever, in 22 years, asked me a single direct question about the nature of my work, she said, I didn't need to ask. A mother knows. It was on the 3rd day, during her direct testimony about why she believed the forfeiture clause applied to me, that she said the sentence that would follow her for the rest of her life. Craig asked her to characterize, for the jury, what she believed my military career actually consisted of. My mother looked directly at me, not at the jury, and said, she never served a day in her life, not one day. She sat behind a desk while other people's daughters did the real dying. 3 jurors visibly flinched. I did not. I had trained for 22 years to sit perfectly still while people said things that were supposed to break me. Jim did not object. He did not even stand up. He let that sentence sit in the courtroom air for a full 10 seconds, longer than any of his 4-second pauses, and then he simply said, "No further questions for this witness, Your Honor. The respondent reserves the right to recall." My mother looked confused by how easily he'd let her go. She had no idea Jim was saving every ounce of his cross-examination for a witness who hadn't even entered the courtroom yet. That witness was General Frank Castellano, who flew commercial from Norfolk, Virginia, in his own suit rather than his uniform, at his own request, because he told Jim in the hallway before he was called. "I want this jury to see a man, not a costume, when I tell them who Rachel Keller really is." He was sworn in on the fourth day of trial. Craig Del Vecchio objected twice before Castellano even finished stating his name and rank for the record, and both times the judge, a 60-year-old woman named Judge Miriam Oyalaran, who had sat on that bench for 14 years and did not seem inclined to enjoy being lectured by an attorney with an expensive watch, overruled him without raising her voice. Jim's direct examination lasted 11 minutes. He asked General Castellano to describe, in terms he was legally permitted to disclose, the nature of the service he had personally witnessed from then-Major Rachel Keller in 2016. Castellano described a logistics failure during a classified operation that had, within 6 hours, become a medical emergency involving 12 American service members and no viable evacuation route, and how then-Major Keller had personally coordinated an alternate extraction under conditions he was not permitted to detail, resulting in the survival of all 12 men, at a level of personal risk that had earned her the recommendation that later became, for reasons of classification rather than merit, a lesser official commendation than the record actually justified. He testified that he had called Harold Keller personally in 2016, at his own initiative, specifically because he believed, and I quote what he said under oath, that a father who raised a daughter capable of what I watched her do deserved to know it, even if he could never repeat the details to another living soul. Then Jim asked the question that ended the case, though none of us in that room, except perhaps Jim and General Castellano, fully understood in that moment how completely it would end it. "General Castellano, is there a formal declassified record that would allow this court to verify any part of what you've just described?" Castellano reached into his jacket and produced a white envelope, sealed, embossed with a seal Jim had already shown Judge Oyalaran privately in chambers that morning, a partial declassification authorized 11 days earlier at the request of the Department of the Army's Office of the Chief of Staff, expedited specifically because a federal appellate attorney with 29 years in JAG had made 3 phone calls of his own the week the trial motion was filed. Craig Del Vecchio stood up so fast his chair scraped audibly against the courtroom floor. "Your Honor, I have had no opportunity to review." Judge Oyalaran removed her glasses, folded them slowly, and set them on the bench in front of her, a gesture the courtroom sketch artist would later render 3 separate times for 3 separate news outlets. "Mr. Del Vecchio," she said, "your client stood in my courtroom 2 days ago and told 9 jurors this woman never served a day in her life. I am going to read this document into the record right now, and you are going to sit down." She read for 4 minutes. A partial service record, 2 combat theater deployments the family had been told were training rotations, a Bronze Star with Valor device, awarded in 2019, that my mother had believed was a retirement recognition plaque, and a single line near the bottom of the 3rd page regarding the 2016 incident General Castellano had described, stating that then Major Keller's actions had directly resulted in 0 American casualties during an operation that Internal After-Action Review classified as having carried an estimated survival probability, without her intervention, of under 30%. When Judge Oyalaran finished reading, she looked up, first at my mother, then at the jury, and said, "This document is classified. All rise." The bailiff called the room to order for a recess so abrupt that I heard 3 separate gasps behind me before the door had even fully closed, and somewhere in that noise, I heard my sister's voice, quiet but audible enough to carry, say to our mother, "She never served a day." "You said that in front of everyone, Mom. You said that in front of everyone." It was the exact sentence my mother had used to try to erase me, spoken back into the room by the one person who had wavered the longest, now finally landing where it should have landed from the beginning. The verdict came 4 days later. The jury found, unanimously, that my mother's petition failed to establish material misrepresentation on any ground, that the forfeiture clause did not apply, and that the original terms of my father's trust, an even split between his 2 daughters, would stand exactly as he wrote them in 2011. Judge Oyalaran, before dismissing the jury, added a brief statement from the bench, that Jim later told me was almost unheard of in a probate proceeding, saying that the court wished to note, for the public record, its recognition of service rendered in silence, at personal cost, by a citizen of this county, who was owed better than what this litigation put her through. Craig Del Vecchio did not look at me on his way out of the courtroom. He resigned from the Franklin County Bar Association's Ethics Committee 11 months later, following an unrelated complaint that, according to two attorneys who mentioned it to Jim at a bar function the following spring, was quietly connected to how he had handled discovery obligations in cases very much like mine. The epilogue unfolded slowly, the way real consequences usually do, without a single dramatic sentence to tie it all together. My mother did not speak to me again for 4 months. When she finally called, in March, almost exactly a year after my father's death, she did not apologize outright, not at first. She said, "I didn't know what to do with a daughter I couldn't picture, so I pictured someone smaller instead." I told her that was the closest thing to an honest sentence she had said to me in 22 years, and that it was a start, not an ending, and that I needed more time before I could call what we had a relationship, instead of a truce. Patricia Hart sent a card that Christmas, unsigned except for her name, with no note, which Jim told me, laughing for the first time in months, was the most honest thing that woman has ever sent anyone. Gregory's divorce finalized in January, on terms considerably less favorable to him than his attorney had originally filed for. Once my own attorney, a family law specialist Jim referred me to, established a clear timeline of his relationship with Sherry Doyle, predating our separation by at least 4 months. He remarried Sherry the following year. I have not spoken to him since the day the divorce was finalized, and I have found, to my own quiet surprise, that I do not miss the version of him that needed my mother's approval of me more than he needed his own judgment of me. Melissa and I are close again, closer in some ways than we were before any of this began, because grief and betrayal have a way of burning off the parts of a relationship that were never built on anything real, leaving only what actually holds weight. She testified, in the end, that she believed me, though the jury never needed to hear it by the time she took the stand. She told me afterward, in the hallway outside the courtroom, that she wished she had said it sooner, before 9 strangers and a judge had to prove it for her. I told her that most people never get a second chance to say the true thing after they've already said the smaller one, and that showing up in that hallway, finally, was still worth everything it cost her to get there. My father never lived to see any of it, but I think, somewhere in the 11 pages of that folder, in the 4 words Arthur Beaumont handed me at the reading of his will, he already knew exactly how it would end, because he was the only person in my family who had ever simply believed me without needing a declassified envelope to do it. If there is one thing I would ask you to carry out of this video, it's this. Somebody in your life is probably carrying a version of themselves you have never bothered to ask about directly, and you may not get a courtroom, a general, or a sealed envelope to correct the record before it's too late to matter to them. There is one detail from that 4th day of trial I still think about more than the verdict itself. While Judge Oyalaran read the declassified pages into the record, the radiator along the east wall clanked twice, the same dry metallic clank it had made every 20 minutes since the trial began, and nobody in that courtroom flinched at the sound the way they flinched at the words. I remember the smell of the room in that moment. Old varnish and coffee gone cold in styrofoam cups on the plaintiff's table, and the particular texture of the folded service dress blues General Castellano had brought in a garment bag but chosen, deliberately, not to wear, leaving them draped over the back of the gallery's 2nd row, like a promise he was saving for a different occasion. My father's manufacturing business, the one he built from a single lathe in a rented garage in 1979 and grew into a 14-employee machine shop off Route 62, went to Melissa and me jointly under the settlement, and we sold it 14 months later to a longtime employee, Tom Reyes, for $620,000, on terms that let him keep every job intact, because that was the one thing both of us agreed our father would have wanted more than either of us keeping the building. My mother attended my re-enlistment ceremony for the reserve component, 8 months after the trial, standing in the back of a VFW hall in Westerville, and when the commanding officer asked if any family wished to pin my new insignia, she was the one who stepped forward, her hands shaking slightly around pins she had never once touched in 22 years. And she did not say anything profound while she did it. She just did it, slowly, and let the room watch her do it. I never did find out what Craig Del Vecchio actually said to my mother in the parking garage that afternoon. The one thing his own paralegal let slip to a court reporter, who mentioned it to Jim 8 months later, and honestly, some days, I think that conversation might be a stranger story than the one I just told you. If you want to hear it, you already know what to do.